The province of Alberta is throwing its support behind Saskatchewan and its controversial pronoun policy. Danielle Smith's government says it wants to join a court dispute over the law and help quash a challenge against it. Mariana's on the story for us today. Tell us about the challenge and, again, how Alberta hopes to get involved here.
Yeah, because this is really uncharted territory, and I'll get into that a little bit more. But basically what this is Saskatchewan's case. It is before the Saskatchewan Court of Appeal, and it all relates to its parents' Bill of Rights case, and it is currently being challenged by a local group there. But now we know that Alberta has applied for intervenous status, which essentially means that it is throwing its support behind Saskatchewan in defense of its student pronoun policy. Now, this is a policy that came into law back in October, essentially saying that kids who are under 16 would need parental consent to change their name or pronoun while in school. But also it is protected under a certain section, Section 33 of the Constitution, also known as the Notwithstanding Clause, which would mean that it would prevent charter challenges. Now, where this is getting tricky is that back in January, this group, which is called Your Pride Center for Sexuality and Gender Division, it challenged this bill, saying that it is violating the rights of transgender, non-binary, and gender diverse youth. We know that the government of Saskatchewan had said that the purpose of this policy is to ensure that parents are at the forefront of these big decisions. Now, there are statements that are released here. Let's start with the statement from the Alberta government. It said in part that Saskatchewan and Alberta agree that the ultimate authority figures in children's lives are their parents, and our provinces are both committed to supporting families and kids so that they can work through their child's unique needs together. Notifying parents and requiring their consent before a child's name or pronouns can be changed in schools and before classroom discussions about gender identity and other sensitive subjects occur ensures the parent-child relationship is respected and paramount. Now, we also heard from the national advocacy group representing Your Pride, and it said in a statement, quote, "We remind both governments that the policy measures legislated by the government of Saskatchewan were found to cause irreparable harm to gender diverse youth by the Saskatchewan Court of King's Bench, and the lives and dignity of the lives and dignity of young people are at stake here." So they will be responding to this once this fully goes through, but as of right now, Alberta applying for this intervener status.
And what are the implications of this case for Alberta?
Yes, because we know that Alberta has its own policies coming this fall, and they would essentially regulate not only names and pronouns of students in school, but also things like gender-affirming healthcare. So what happens potentially here in the Court of Appeals in Saskatchewan could also potentially impact what's happening in Alberta. And as I mentioned, we spoke to a legal expert on this who says this really truly is uncharted territory.
I think Alberta wants to have the power to use the notwithstanding clause in a way that would be unquestioned by Alberta courts. And if they can point to a Saskatchewan case that says, look, that Saskatchewan decision has already held that once you use the notwithstanding clause, the whole case is effectively evaporated. Alberta would prefer that legal outcome if they have the notwithstanding clause in their back pocket.
So Saskatchewan watching this closely, Alberta, as well as advocates within the LGBTQ plus community. So again, keeping a close eye on the developments here and, of course, what could happen not only there in Alberta, but also what this could mean across the country.